Thank you, Madam President. Madam President, I beg to move that a bill entitled An Act to Amend the Summary Courts Act, Chapter 420, to remove the requirement of consent for joinder of complaints in summary judicial matters be now read a second time. Madam President, the bill before us today is 2 clauses in length. The first clause is literally the short title, and the second clause is the substantive amendment that we propose. This bill is anchored in the continuous reform of the criminal justice system. The reform of the criminal justice system is perhaps the most important aspect of engagement that a parliament can participate in, largely because for all of us in Trinidad and Tobago, we desire to feel a sense of security. One can only feel a sense of security if there is a degree of resonance in the manner in which our judicial system works. Madam President, for persons who are not familiar with the law and the structure of the criminal justice system, suffice it to say, the law, as it relates to how we manage charges, is split between 2 areas. 1, there is the indictable approach, and 2, there's the summary approach. The indictable approach is really the relegation of serious matters before a serious court, as it's put in very simple terms, where persons are invited to be judged today either by a judge sitting alone in the assizes or by a judge and jury, after a process of preliminary inquiry has been engaged in, where a filtration system is applied to see if a matter can effectively move beyond the laying of charges and into the assizes, which is the High Court setting. In the summary court context, we have the position of matters described as less serious than indictable offenses. But, Madam Speaker, Madam President, the fact is, today, we really do treat with the summary courts, or the magistrates' courts, now called district courts. We really deal with some very serious matters in there. Financial crimes, intellectual property, securities matters. And therefore, it is sufficient to say that at all levels of judicial involvement, be it in the High Court or in the district courts as we have them now, serious matters are done. Now, the fact is further borne that the Summary Courts Act, Chapter 420, is an Act of Parliament now standing more than 100 years old. It's an Act of Parliament born by Act Number 9 of 1918. And the law as it stands is that our district courts, meaning the magistrate courts, are dealt with by magistrates, now called district judges. Our magistrates are creatures of statute. Magistrates are not anchored in the Constitution. They are in fact anchored in the Summary Courts Act. And out of interest and connected to this, Madam President, it's material to note there shall be such number of magistrates in the public service as required for the purposes of this Act. That's Section 3 of the Summary Courts Act. In dealing with the fact that magistrates are creatures of statute, in dealing with the simplification of the districts in which magistrates now sit, because we now have divisions that are simplified. There is North, there is South, and there is Tobago. Magistrates are bound to act in accordance with the law. And in this case here, in dealing with complaints in the summary court arena, magistrates are bound by Section 64 of the Summary Courts Act to act in accordance with the strict requirements of this Act. That, Madam President, brings us to why we are treating with the amendments today. Section 64(2) is the part of the Summary Courts Act, Chapter 420, which deals with the issue of what we call joinder of complaints. Joinder of complaints is where 2 or more complaints are made by 1 or more parties against another party or other parties. Perhaps some people are not aware, but matters can be brought to the Magistrates Court under the Summary Courts Act by persons named in law, meaning policemen or other persons, or by individuals themselves. There is the concept of private complaint. And if we turn briefly to the statistics before the Magistrates Court, the District Court, and the reason for the amendments that we propose today, Madam President, permit me to say, if we look at the number of complaints, that is summary court matters, coming before the magistracy, if we look to the period 2016 right up to 2020, the number of summary court matters are as follows. In the year 16 to 17, 14,927 matters came by way of named state complaints. 8,808 came from private complaints. That's roughly 26,000 matters in the year 2016 to 2017. 2017 to 2018, there were 17,012 magistrate complaints brought by the state, and there were also on top of that 8,242, together comprising nearly 26,000 matters for that year. 2018 to 2019, there were 14,360 matters by the state and 7,923 by private individuals, nearly 22,000. If we looked at 2019 to 2020, there were 10,862 matters and 4,520 further matters brought by private complaint, coming down to somewhere close to 15,000. If you look to the year 2020 to 2021, there were 13,925 matters brought by the state, 1,397 by private individuals. Now, Madam President, the fact is, upon becoming Attorney General and having the responsibility for this area of law, the average figure of complaints and matters before the magistracy stood anywhere between 126,000 cases per year up to 146,000 cases per year. And whilst there were complaints in Trinidad and Tobago asking for night court and asking for faster justice, the fact is that people were not taking conscious reflection of what the system comprised, what was before the 43 magistrates in the 14 districts as it then stood. Today we have 3 districts, and the number has dropped from 146,000 cases per annum. We have eliminated 8,500 matters by decriminalizing marijuana, and we have removed 104,000 cases per year by converting the system of every traffic offense being an offense and instead introducing violations. The consequence of that has been that we have had a 65-year low in road traffic deaths, just by way of understanding. Now, Madam President, in looking at the average of 15,000 cases per year that are summary offenses, and in factoring the situation as it now exists, that we now have virtual appearances in the Magistrates Court, we now have defendants appearing in virtual access centers, some of them even appearing from the prisons. Now we also have, Madam President, the fact that we are in active case management, not by justices of the peace as existed in 2015, not by clerks of the court who are untrained professionals as existed in 2015, but now we do case management pursuant to rules of court, criminal proceedings rules, and also, Madam President, via a registrar of the district court. So we have taken this step to professionalize the magistracy. We have taken this step to provide full magisterial immunity. We have taken this step to adjust what is in consideration of the caseload by disaggregating what is actually before the court, by taking children's matters and putting it in the children's court, Madam President. And I should tell you, Madam President, for the period 2017 to 2018, in the children's court we dealt with 211 matters, in the state filing, 111 by the private route, 18 to 19, 197 in the children's court by the state, and 213 in the private arena. 2019 to 2020, 111 for the state, and 40 for the private matters. In 2020 to 2021, 83 in the state and 80 by private matters. And as we look to the whole concept of case management, as we treat with case management now, statistically, of these 14,000 matters per year, private and public, summary court matters, I can tell you, Madam Speaker, Madam President, 20%, if we look at the Northern Division alone, 20% of the matters are for multiple offences. And if we look to how many multiple parties are involved, we are anywhere close to 6 to 10% of the matters involving multiple parties. So what's the mischief that we attempt to treat with today? What's the legislative aim that we're interested in? The fact is, we are in an aggressive case management now at the judiciary. Lawyers would have received by way of circulation from the Law Association, certainly the Attorney General's office has received by way of circulation from the judiciary, the fact that case management from the Court of Appeal right down to the Magistrates Court is in an aggressive, the courts are in an aggressive state of case management. And therefore, when we look to the analysis of how we are going to treat with matters, how we are going to ensure that justice is delivered on time, because justice delayed is certainly justice denied. That is where the rationale for this amendment comes in the reformulation of Section 64.2. Section 64.2 says, the present law, that you have two conditions precedent to meet. There is a judicial discretion to consider joinder, but the conditions precedent are that if you have multiple matters involving multiple persons, number one, you have to inform the defendants. And number two, they must consent. And in default of consent, you are bound by the statute, the Summary Courts Act, Section 64.2, to hear the matters separately. Now, there is an anomaly in the system because, Madam President, when we look to how our indictable proceedings are treated with, our indictable proceedings do not find themselves confined to the issue of consent. In the indictable arena, that is in the High Court setting, that is in the preliminary inquiry setting, when we look to the joinder of indictable offences, and we look to the Criminal Procedure Act, Chapter 1202, Section 13, or we look to the Criminal Procedure Act, First Schedule, Indictable Rules, Rule 3, charges for more than one offence may be joined in the same indictment. And very importantly, when we look to the case law relating to joinder in indictable matters, there is no encumbrance of the requirement for consent. And that is set out most usefully in the leading case of Bola Nandlal versus the state, 1995, 49 WIR at 412. So in Trinidad and Tobago, in relation to our very serious matters, our indictable proceedings, you can have joinder of parties, you can have joinder of matters pursuant to the rules of court, pursuant to the legislation, and consent is not a condition precedent. That is not to say that the court is not bound to consider the interest of justice, or that the court is not bound to consider factors of abuse of process. I mean, the very case of Bola Nandlal versus the state set out in clear terms what abuse of process looks like. In that case, where a second indictment followed the first indictment, and there was an abuse of process against the allegation standing against the magistrate who came before the court. Abuse of process and joinder obviously fall to be considered against the complexity of the matter, the number of charges, the number of defendants, the probable length of the trial, and that overriding objective, if I use the term, of the interest of justice is something that the magistrate, if the magistrate is sitting in the preliminary inquiries route, or a judge of the High Court is sitting on, has to consider. Now, bear in mind, Madam President, that we are not treating with the confining of jurisdictions. In 2015, when this government entered, Magistrates had to deal with matters separately from High Court judges. As you are well aware, in the criminal division and in the family and children division, we removed the limitation on jurisdiction so that a judge can actually hear a summary offense. And as we move towards the Administration of Justice Act, that is the abolition of preliminary inquiries, as we call it, AJIPA, A-J-I-P-A, as we move to proclaiming AJIPA in full form, subject to certain reviews going on in the Office of the DPP and the judiciary now, what is intended is that at sufficiency hearings, that the master of the court who is case managing can consider treating with summary and indictable matters and therefore issues of joinder, etc. So we are navigating our way to ensuring that there is proper use of judicial time. Madam President, permit me to say the recommendations before us have arisen because of the constant functioning of the Criminal Justice Committee. At the Criminal Justice Committee, this particular matter was discussed. Then sitting acting Chief Justice, Madam Alice York Suhon, Justice Lucky as the acting chairman, the Honourable Madam Justice Pemberton as chairman of the Bar Bench Committee, I as Attorney General attended, the Court Executive Administrator, the Chief Magistrate, the Registrar, the Honourable DPP, Mr. Roger Gaspard, the President of the Law Association, Mrs. Sophia Choate, the President of the Legal Aid and Advisory Authority, Mr. Gilbert Peterson, the Director of the Public Defender's Department, Ms. Haseen Sheikh, the Assistant or Deputy, Director of Public Prosecutions, Joan Honoré Paul, the Commissioner of Prisons, the Deputy Commissioner of Police, etc., etc. In this committee, we considered the reformulation of Section 64(2). This committee proposed and accepted that we ought to amend 64(2) to remove the consent requirement, that we should leave it to the interest of justice, and this committee considered the fact that there were multiple appeals coming to the Court of Appeal. Bearing in mind we have no procedural appeals in respect of magisterial matters, appeals were still coming before the appeal court on the issue of the statutory requirements of Section 64(2). Madam President, permit me to put on the record that I think the leading case in this matter is really one that we ought to reflect upon. Would you remind me, Madam President, what time is full time?
You finish at 2 minutes to 3.
Thank you so much. So, Madam President, there's a very useful judgment coming from the Court of Appeal, and I refer here now to Magisterial Appeal number 930 of 2008. It is the case of Fazal Dindial and Rajesh Deosaran, Police Constable number 12861. In that case, this magisterial appeal, the panel was Madam Justice of Appeal Alice York Suhon and Mr. Justice of Appeal Prakash Musai. And the date of delivery of that judgment was the 15th of December 2017. It's a very useful judgment because the Honourable Justice of Appeal Musai, in setting out the dicta that the case volunteered as the ratio, the judge focused specifically on Section 64(2) as one of the several grounds of appeal. And in it, we got the benefit of the historical antecedents of this particular law. In fact, Mr. Justice of Appeal Musai reflected upon the fact that the first version of Section 64(1) was enacted in 1918 as Section 61 of the Summary Convictions Offences Procedure Ordinance number 9 of 1918. The Honourable Judge went on to demonstrate where Section 64(2) came from and, in fact, set forward the ratio in Bali versus Ninvale, Ninvale, that is a case in 1964 found at 7 WIR at 430. And the Honourable Judge reflected, and it's in the judgment, that the object of Section 64(2) is to prevent a multiplicity of proceedings. The Honourable Justices of Appeal reflected upon what the common law of the United Kingdom is. And in the proposal that we make today to amend Section 64(2) to bring it in line with the indictable route, we are also bringing it in line with the common law of the United Kingdom. And the common law has been perhaps best set out in the case of Clayton versus Chief Constable of Norfolk. That is a case 1971, Appeal Cases 29 at page 39. And in looking at the dicta of Lord Roskill, again, the parameters were set forward that the common law of England says that while statute confers a discretion on a magistrate as to joinder, and I'm quoting from paragraph 20 with your leave, Madam President, it says this discretion is not unfettered and must be exercised judicially. There is no reason why, as a matter of principle, the test postulated by the House of Lords in the leading case of Clayton, a decision based on the joinder of informations in the Magistrates' Court, should not be apposite for the exercise of the discretion under our statute. So these are the words of Mr. Justice of Appeal Prakash Musai. He goes on to say, accordingly, the court should ask itself whether it would be fair and just to the defendant or defendants to allow a joint trial. And he was quoting from Lord Roskill. So this decision, the Dindial decision, the Honourable Justices of Appeal considered the magisterial appeal. They said, listen, we're going to infer that there was consent because there was representation. We're going to set out what the bare minimum for that is. We're going to say that you need to look at the interest of justice. So they looked past the issue of consent on a very narrow and technical ground that the defendants were represented and that the magistrate had engaged in conversations with the legal counsel for the defendants. But what Mr. Justice of Appeal Musai put on the record at paragraph 27, before concluding this issue and proceeding with my analysis of the other arguments raised, I find myself in the unenviable position of having to remind judicial officers of the importance of complying with statutory requirements. Precious judicial time is spent hearing and adjudicating over grounds of appeal based upon a magistrate's failure to comply with statutory requirements, or having to navigate and make sense of ambiguous approaches to compliance. It is somewhat disquieting to observe that this apparent trend centers around adherence to the least complex and decidedly straightforward of statutory duties. Regardless of any apparent simplicity or lack thereof, it was reiterated most recently in the Privy Council case of Wright, that is W-R-I-G-H-T, versus the Queen. Statutory duties are not mere formalities, and a failure to comply can, in appropriate circumstances, amount to a material irregularity. Specific to section 64(2), it is but the work of simple comment and inquiry to ensure that a defendant is made aware of his right to a separate hearing and that he consents to proceed with a joint hearing is obtained. It is the responsibility of magistrates to ensure that these requirements are complied with. Now, I've taken care to read into the record paragraph 27 of the Dindial judgment from the Court of Appeal because that paragraph demonstrates where it goes wrong. And the magisterial appeals demonstrate the fact that entire trials can be aborted because formalities were not complied with, and therefore justice was not carried out. Therefore, the legitimate aim of this particular bill is to remove the statutory requirement that there must be consent, and that without consent, or if there's expressly no consent provided, that you must have separate trials. Our law is replete with case law that demonstrates that the interest of justice argument is an appropriate consideration in the common law and in our case, as we propose this amendment, in statutory reference. Because, Madam Speaker, I'd like to remind that the Clause 2 of this bill proposes specifically that where two or more complaints are made by one or more parties against another party or other parties in the same matter, and the complaints are in that matter founded on the same facts, the complaints may, if the court thinks fit, be heard and determined together unless the court determines that separate proceedings are required in the interest of justice. So we preserve the constitutional underpinning of the separation of powers. We leave it to the judicial mind to consider the propriety of the joinder of matters. We leave it to judicial consideration to consider the interest of justice argument. Obviously, the interest of justice argument fits within the rule of law and fair trial proceedings established in our Constitution, and obviously they include the issues of abuse of process considerations. I'd like to say that we ought to be warmed by the fact that Blackstone's has clearly set out the route in the United Kingdom in relation to joinder of summary matters, and I refer specifically in looking at the most recent version of Blackstone's at page 2229, when we look to paragraph D2146, again the reliance on the Chief Constable of Norfolk finds itself, and that is the Clayton case. If we look, Madam President, to jurisdictions that are close to us, I want to put onto the record that Barbados, in its Magistrates Court Act, Chapter 116A as in alpha, sets out at paragraph 95 of their law, section 95, the fact that the interest of justice in joinder is the factor to be considered. I also wish to refer you to the law of St. Vincent and the Grenadines. I refer specifically to the Criminal Procedure Code, Chapter 172, and I note that their section 70, subsection 6, again treats with the interest of justice and joinder where consent is not a prerequisite. I refer as well to the laws of Jamaica, the Criminal Justice Administration Act, and I refer specifically, Madam President, to section 22 of that act. And the caveat there, such charges may be tried at the same time unless the court is of the opinion that such person is likely to be prejudiced or embarrassed in his defense by reason of such joinder. That in the Jamaican case law, in their Supreme Court, all the way up the road, as we say, has been held to be the interest of justice argument. Lastly, I'll refer to the laws of Guyana, Summary Jurisdiction Procedure Act, Chapter 1002, and I refer specifically to Section 29, where again the interest of justice argument finds express mention in the laws. So, Madam Speaker, there is ample, Madam President, there is ample precedent in the common law, in the United Kingdom, in the Commonwealth Caribbean, in our own laws, when we deal with indictable matters and we look to the criminal procedure in relation to indictable matters, and also in the rules, the interest of justice is the point of reference. The issue of mandatory consent for joinder is not a feature of our indictable proceedings. When we look to the proposed amendments and we look to our own Court of Appeal considerations in the Dindial case, whilst we can rely upon the fact that our Court of Appeal says, look, provided that you have complied with certain formalities in a bare basic way, you are still subjected to the vagaries of not having done it, and therefore you're going to be subjected to magisterial appeals. If we look to the desire of the government at present, having radically transformed the laws that treat with the criminal justice arena, having focused upon plant and machinery, people, processes, and the law, having had the ability by way of amendments and the creation of divisions of court, having introduced rules of court, be they the children's rules, be they the family proceedings rules, the criminal proceedings rules, having given full magisterial immunity, having simplified the districts of court into 3, having allowed for virtual appearances, having professionalized the magistracy by the introduction of registrars of the court and filing arrangements at the court office, being about to open nearly 129 new courts as the judiciary has already started occupying in part the waterfront courts with the build-out of the Hall of Justice as the criminal arena, with the expansion of the Magistrates Court in San Fernando, the opening of the Siparia Court, the opening of virtual courts a court being now a laptop, Madam President, a laptop with virtual access centers, Madam President, we are bound to continue to further analyze what is before the court. And this law treats with joinder for multiple parties in a multiple charge scenario, contemplating that you may have private matters and also public matters, meaning matters brought in the name of the state. And in these circumstances, as the case management is as active as it is, we wish to further simplify the law within the boundaries of sensibility and jurisprudence, and certainly within the confines of our Constitution. Madam President, I'll say as I begin to end my contribution now, that I give notice that there are a significant number of other amendments to come to us. We are in the course of scrubbing the final arrangements for the full abolition of preliminary inquiries. The operationalization schedule for that is imminent. But as we do with every law before proclamation, we check with all of the stakeholders. So, Madam President, I look forward to the contributions of honourable senators. Certainly, their reflections always redound to our best interests, and in those circumstances, I beg to move.
Honourable senators,